sleep. And any who woke were just counting sheep. But the end is near, and all we see is our hate is a disgrace. We don't have time to waste. If we don't learn to love again, it's all over for us.
Good evening, everybody, and welcome to a wonderful Thursday here in Stony Plain. We're at the Fresh Grill Kitchen, hanging out with some of our fans of the show. And if you want, there's still room, but it's very windy out there, so be very careful and be very safe. And who knows what's going on? Mark Carney. Yeah, the Fresh Grill Kitchen is Stony Plain. Mark Carney is in town. He's in Edmonton, so he's just down the road, and maybe he brought this horrible weather with him. Or maybe it's a bit of an omen because he just finished announcing that he is running for the Liberal leadership, which puts him a couple votes away, a couple evenings away from actually being the prime minister. Yes, he can be the prime minister, even though he doesn't have a seat. And if we want, we can get into that with John Carpay, who's our excellent guest here tonight from the JCCF, the Justice Center for Constitutional Freedoms. And he's here to talk to us about the proroguing of the Parliament that Justin Trudeau gave us. And we're going to talk about whether or not that's legal. Should they have done it? And if it's not legal, what can we do about it? Because there's a lawsuit now with the JCF involvement to address it. And we're also going to be taking a look at John's new book today. I'm sorry I don't have my notes in front of me. We had a little bit of a technical glitch right before we started, but we'll make do with it. But John also just released a book, and we'll get into some of those details. And also, what can you do to get involved and help out? Well, there's petitions, there's donations, and there's other ways to help the JCCF. So we'll talk about that as well. So without further ado, let me go ahead and bring in Mr. John Carpay. Good evening. How are you?
Hey, good evening. Good to see you.
Yeah, apologies. The title of your book, can we get that out?
It is Corrupted by Fear, How the Charter Was Betrayed and What Canadians Can Do About it.
Excellent. What caused you to write that book?
Well, so much went on for 4 years. We got some really bad court rulings, and it really took a while for all of it to sink in, just how atrocious these court rulings were, that we have judges basically repeating what they've heard on the CBC, making assertions in their court rulings that are not based on evidence before the court, which is a very serious problem. And I appeal to people as well who supported lockdowns and supported vaccine passports to say you should be really concerned when judges are repeating a media narrative in their court ruling that's not backed by evidence. If we accept that as being okay, it just opens the door even wider for governments to violate our rights and freedoms and not be held to account by the courts.
Well, the title is Corrupted by Fear. So you're considered this a type of corruption or coercion or trying to get people to do something when it's not what they normally would do. That's really what corruption means. So why would it be corrupted by fear? Do you think this is intentional on their part?
I can't look into the hearts and minds of judges to know what's intentional or not. But the title emerged because at various public meetings, I leave Calgary roughly once a month, and I go to Medicine Hat, Lethbridge, Edmonton, Vancouver, Toronto, Montreal, you name it. And usually when I'm out of town, we have public meeting. And I got asked so often in 2021, 22, 23, 24, in the last few years, I keep on getting asked, well, what's going on with these judges? Are they getting paid off? Are they getting bribed? Are they getting a threatening phone call from the prime minister? And my answer has been no. I do not believe for a second that the judges are getting a thick envelope full of $100 bills. I don't believe that Trudeau or judges or the World Economic Forum is phoning judges or threatening them. But what creates this departure that I've not seen before in I've read thousands of court rulings during law school and the years thereafter, and I've never seen this departure where judges are just not even explaining why they're ruling for one side and not the other. So they rule for the government. They say, well, the government's evidence is better, it's stronger, it's more persuasive. They never explain why or how the government's evidence is better or stronger. And so I think, okay, they're not getting threatening phone calls from powerful people. They're not getting envelopes stuffed with cash. What is driving the judges to not look at the evidence that's been placed before the court? And my thesis, and I don't know what's in their minds and hearts, my thesis is fear. They got corrupted by fear the same way that millions of other Canadians fell prey to this round-the-clock, every hour, media fear-mongering, making false claims by exaggerating how bad COVID was and making it out to be far worse than what it was. And the judges fell prey to that, so they were corrupted by fear.
I think that's a really good assessment, and what you identified is, and that's where media can play the role. So let me just highlight the Coutts situation. I think you're familiar with that down in Lethbridge, King's Bench, and we'll just talk about the bail. The way the bail system is set up is, especially if you're charged with something like murder or attempted murder or conspiracy to commit murder, it's a reverse onus. And it's actually on the defendant to go ahead and show that they're not dangerous. So with the Chris Carber, Tony Olenek, Chris Lysick, and Jerry Morin, their bail, the judge was handed ITOs. ITOs are information to obtain. And these are basically real world narratives at the time that the police, fictional or not, put together for the court to consider. And these were fear-based. So we had the Canadian Anti-Hate Network in there. We had Vice Media in there talking about a national organization that had all of these resources ready to take over Canada. And it was a real fluffed up piece. And if you listen to the RCMP press conference on February 14th, 2022, you really would have thought we were just moments away from being taken over by an organization. So there's a lot of fear there. And because of that, bail denied. And you would think, rightfully so, given the information then. Fast forward a couple of years in the trial, the jury dismissed and found not enough evidence to convict the men on those particular charges. So they were vindicated, or at least acquitted, on conspiracy to commit murder. But they stayed in pre-trial with no bail based on those decisions. And that was 100% fear-based. The defense could not convince the judge there's no fear here. These are not dangerous people because of the narrative created by the media, used by the Crown and the RCMP. Is that the kind of fear-based corruption you're talking about? Because these people were in jail pre-trial.
The short answer is yes. I have not followed the Coutts proceedings closely, and it's not a lack of interest or concern, but there's a lot on my plate, and the Justice Center lawyers, that was not one of our cases, so I was not following it closely. But everything that you just said, it aligns 100% with what I've seen in the court rulings that I've analyzed in the book, where, as one example, in the Gateway versus Manitoba decision, the judge declared that COVID was unprecedented and that it was the worst pandemic in a century. And both of those claims are not supported by no evidence before the court. COVID was not unprecedented. We had the Spanish flu of 1918, which was 100 times, if not 1,000 times worse. And we had the Asian flu of 1957, the Hong Kong flu of 1968, both of which were more deadly than COVID. And so the judge makes these false assertions. And of course, he doesn't reference any evidence. I mean, there's no evidence to support them. And he writes this into his court ruling as if this is some finding of fact that he's entitled to make, when it's 100% based on media fear-mongering.
Yeah, correct. And I was about to say that, the media fear-mongering, because that's all he's running with, or she, is the talking head on the screen that just replicated whatever the government said. How does judicial notice play into this as well? Because this was taken on several issues with the courts.
Well, one of the most egregious examples was a judge in Saskatchewan, Michael McGaw, appointed by Harper, not by Trudeau. And he ordered a 12-year-old girl to be injected with the mRNA vaccine, contrary to the girl's wishes, contrary to the mother's wishes. And if that wasn't bad enough already, he went on to take judicial notice, which it's not a bad tool in a judge's toolkit. If you're dealing
when used correctly, if you're dealing with somebody who says that the gravity doesn't exist, or the earth is flat, or something, there's a certain line in the sand where the judge is going to say, look, I'm taking judicial notice of X.
And so it's a valid tool, because you can't have in court cases that, every crazy idea needs to be proven with evidence, but it's been abused. So here the judge went on to say that he took judicial notice of the fact that the mRNA vaccine is safe and effective for adults and children. And he says he bases this on assertions made by Health Canada and the Saskatchewan Health Authority. So it's like a government asserts that a vaccine is safe and effective, therefore it is. And it's a very sick, perverse, extreme deference to government that is not warranted, and no court in any circumstance should accord that kind of deference to government.
Requirement of the mandate that the government was in the right to do that. In Alberta, we kind of had the Ingram decision, which did a bit of a test for Section 1 and came to the conclusion that it was reasonable and demonstrably justified. So we did kind of have a small challenge around the effectiveness and the mandates, but the government's narrative upheld. And now we have, and I know you've been paying attention to this one, the Bill of Rights here in Alberta. We've had some modifications to it, and I don't know if it's going to protect us next time around. Do you have a comment on that one?
Ultimately, our rights and freedoms are protected by culture, which means that if 50%, 70%, 90%, the higher the better. If Canadians cherish constitutional rights and freedoms in their hearts and understand them with our heads, then that's really what protects our rights and freedoms. If you think back to 1982, before the Charter, we had a common law understanding that criminally accused person had the right to remain silent. So no confessions can be extracted by use of torture. The right to remain silent, the presumption of innocence, onus on the Crown to prove guilt beyond a reasonable doubt, and the right to a fair trial before an independent judge, and the right to face your accuser and to question your accuser or have your lawyer question the Crown's witnesses. All of those things were solidly entrenched in our legal system without a charter, and that shows that it worked because 99% of Canadians just understood that a man is innocent until proven guilty and has all these procedural rights. And so we've had a cultural decline, and unless we reverse that, the wording of the Charter or the wording of the Alberta Bill of Rights is not going to save us until we ourselves, and we educate ourselves and our children and our grandchildren about the free society being morally superior to repressive regimes, whether they be communist or fascist or theocratic or anything else.
I like the way you put that, and it is up to us to teach our next generation and the people around us. So thank you very much for doing shows just like this, and for all your work at the JCCF, because this is part of what you do is education, and you're trying to teach people as well. This current matter that you're going into, so you put out a post, I think it was on the 9th of January, that there's a lawsuit about the proroguing of the government. Before we jump into that, can you tell us what does proroguing Parliament mean, and what are some of the consequences of that?
So the prorogation of Parliament is kind of halfway between two extremes. One extreme is you dissolve Parliament and elections follow after Parliament has been dissolved. And with the dissolution of Parliament, all parliamentary procedures stop, not only question period, but the committee work, the right of committees to ask questions of cabinet ministers, the right of Parliament to hold the government to account. Everything stops. Every bill that is, whether it's passed first, second, or third reading, unless it's been proclaimed into law, every bill dies. So that's dissolution followed by an election. On the other extreme, you can have an adjournment of Parliament or a recess of Parliament, which means that there's no daily question period, but otherwise Parliament does continue to function with its committees and being able to hold the government to account to a considerable extent, even without question period. Prorogation is halfway between the two. Prorogation means that Parliament is shut down entirely, just like dissolution, but there's no election following prorogation. And so it is appropriately used when a legislative session of Parliament, which could be for 10 months or 2 10-month periods, when that comes to a natural end and the government's business has been concluded, The government has tried to pass legislation in keeping with the throne speech. And so prorogation of Parliament is not a bad thing, but it should not be, it should be used in the national interest when Parliament is kind of naturally winding down. And after prorogation, you need a new throne speech to start off the next session of Parliament. So our court action is saying that Trudeau's use of prorogation in this circumstance serves only the benefit of the Liberal Party of Canada, does not serve the best interest of the country. So it's an abuse, it's a wrongful use of prorogation. And we're saying that the advice that he gave to the Governor General was unlawful or illegal. And so we're asking court to set aside the prorogation. And we're relying on a very strong precedent 2019 decision from the United Kingdom Supreme Court.
Yeah, kind of interesting that it's a very recent decision, because in the UK they tried to do the same thing, did they not? Can you take us through what happened over there and what led to the Supreme Court decision for them?
So in 2019, Boris Johnson became Conservative Party leader and Prime Minister of a minority government, and he was intent on seeing the results of the referendum honored sooner rather than later. The British had voted by a narrow margin to leave the European Union in 2016 in a referendum. 3 years later, these negotiations were ongoing, and they could never work out the details of what the departure of Britain would look like. So Boris Johnson's view was, we have to tell the European Union that if we can't come to terms and agree on the details, we're going to leave the European Union without a deal. So it was a no-deal Brexit. He favored that, but the majority of MPs, because he had a minority government, were not in agreement with that. They wanted to continue negotiations. So Prime Minister Boris Johnson prorogued Parliament for 5 weeks. Usually it was only 1 to 3 weeks that Parliament was prorogued. He prorogued it for 5 weeks, and immediately court actions were filed, and they made their way up through the chain all the way to the Supreme Court. From the time the first action was filed in a lower court until the United Kingdom Supreme Court rendered its decision was about 4 weeks. So they handled it quickly. And the court ruled that this prorogation was illegal because the Prime Minister was trying to avoid the scrutiny of Parliament on this very important issue of the how and when the United Kingdom would leave the European Union. And so they noted the principle of parliamentary sovereignty, and that the government is accountable to Parliament. So Parliament is above the government. Government needs to enjoy the support of the majority of the MPs. And this is a longstanding ancient principle, which they felt Boris Johnson was violating by proroguing Parliament in order to avoid scrutiny. And they said that is improper. And so we are arguing in our Canadian court action that those principles from that court ruling should be applied here in Canada, because Trudeau's prorogation of Parliament was illegal. It was done only for the benefit of the Liberal Party of Canada, and that's not a good enough reason to prorogue Parliament.
Yeah, you're right, because he did his faux resignation or resignation with conditions. He did that, and then he prorogued at the same time. So that wouldn't normally be the case. So Trudeau Sr., he resigned as well. Did he prorogue the Parliament?
I believe not, but I'm not sure. I'd have to look at that. I don't think so.
Okay, so I think your position here is there was no benefit to the people at all to have the Parliament prorogued, other than maybe some bills dying that aren't popular. But the committees all stopped, correct? Everything that was being investigated and worked on has stopped?
Yes, right now, Prime Minister Trudeau and the cabinet are ruling the country for 11 weeks. That's the problem, too. It's part and parcel of this. If he had prorogued Parliament for a week or 2 or 3, okay, fine. Parliament will be back in session and can proceed with a non-confidence motion if MPs want to go in that direction. This is 11 weeks. It's almost 3 months where we have a government that is operating without any accountability to Parliament at all. He could have just adjourned or recessed. That would be different. But this prorogation is a total shutdown of Parliament. And so it's just not an appropriate use of prorogation.
Now, it's coming back March 24th, unless you're successful and it comes back even sooner. But what's special about that date? Something about some costs and some budget needs to be addressed? Do you know anything
If
about
Parliament, if Parliament does not meet again to approve of the government's expenditures, it means the government cannot spend money after March 31st. So they do have to come back to authorize either a new budget or an interim budget. They have to authorize continued spending past March 31st. So that's why he didn't want to prorogue it longer than that. But again, 11 weeks to March 24th is too long of a time.
Yeah, and we're likely coming back with a different PM too when that comes back. So how would that work? So Carney, he put his hat in a ring. It's official now. He's running, and they're expecting to have a result from March 9th, I believe. They said they'll announce the new leader. So how would that work? Like on March 10th, he gets the keys to the PMO, or is it on March 24th when we come back? Like, how would that work?
Well, technically, the country or a province could have a prime minister or premier who is the premier, but who is not elected to the House of Commons. By tradition and as a constitutional convention, that cannot be a permanent state of affairs. So it's okay under our system for a new person to win the leadership race of the governing party. You take Danielle Smith in Alberta. She won the UCP leadership race. She became premier, but there's grounded in tradition, there's a very strong understanding, and I think if we had to take it to court, this would hold up, that it's part of our constitution that the prime minister must be a member of the House of Commons, or the premier must be an elected member of the Legislative Assembly. So Danielle Smith was premier briefly without being an MLA, but as soon as reasonably possible, she ran in a by-election and became an MLA. So in similar fashion, we could, if Mark Carney beats out Chrystia Freeland, then we could briefly have a prime minister who was not a member of parliament. But everybody understands that that's not a situation that you can carry on for months or years.
Yeah, but is there a law that requires it? If you're using the word tradition and understanding, that makes me nervous when we're dealing with the Liberal Party, because we understood what the Emergency Act was meant to be used for, like last resort, like we have no other choice. But they pulled that tool out pretty quick, and reasonably justified and demonstrably justified. Again, they have a very different definition than we did. We went through the POEC, we heard their arguments, and then Mosley came along and basically said, no, you guys really didn't have it. So when I hear things like, well, traditionally and constitutionally it's implied, that makes me nervous, because unless it's in black and white, I don't know if they're going to be forced to. Is there anywhere that you're aware of that will require them to call an election, let's say by October?
Well, if the Parliament comes back into session on March 24th, and that would be with a throne speech and legislative agenda, so on and so forth, then right after the throne speech, one of the MPs could say, Mr. Speaker, point of order, I have a motion of non-confidence in this government.
Yep.
And that right after the throne speech, you can have a vote of non-confidence, and immediately you go into an election right then and there. In terms of it not being written down, this goes back to the importance of that this love for freedom grounded in justice based on truth, not an unhinged freedom that can fly in any direction, but freedom in a proper context, rooted in justice. If that's not enshrined and reigning in the hearts of people, and if it's not understood by the mind, then you're really in deep trouble, because then you end up having to go to court if the government said, well, we're going to have an unelected prime minister running the country just because he won the leadership race of his party. We want to be in a situation, even here with prorogation, where it's just understood that you don't abuse prorogation for the benefit of one political party just because they need to, they need time to get their act together and elect a new leader. That's not a constitutionally valid reason. So it's similar to people understanding prior to 1982 that an accused person has a right to a fair trial and has a right to be presumed innocent, et cetera, et cetera. That was not written into, we didn't have a charter. It wasn't written into a document per se, but there's this profound understanding. Everybody understood, the judges, the lawyers, the people, the prosecutors, everybody understood that there's a presumption of innocence and we have a right to a fair trial.
Now, that's under normal times, and I would even argue peaceful times. But what happens under emergencies? If there's an economic emergency or some sort of health emergency or a combination of many emergencies, do things start to change under those conditions? Would there be a requirement to have, let's say, an election if we were in the middle of a war or we were having an economic collapse, like a full-blown one? So what could happen if an emergency is happening to Canada?
Well, we have a precedent in the Commonwealth. In India in the 1970s, we had Prime Minister Indira Gandhi, who was democratically elected. And I don't know if she was in her first or second or third term, and she declared a state of emergency because there was a severe economic crisis, and this ended up with journalists being locked up, and it was a martial law. And basic rights and freedoms were taken away from the people. And the state of emergency lasted, I don't recall whether it was months or 1 or 2 years. So, I mean, conceivably that could happen in Canada. But then that gets back again to what is the cultural acceptance? What are the cultural expectations? If you have 90% of Canadians saying, no, this is totally unacceptable, that's going to trickle up to the senior civil servants and the army, the military, the Air Force, the courts, the judges. If the whole country is on side with this idea that you need a true emergency, but I have to agree with you, it is frightening when you saw how blithely, cheerfully, and sometimes enthusiastically Canadians gave up their basic rights and freedoms based on media fear-mongering and false claims about COVID being, far worse than what it actually was. And if people are willing to give up their rights and freedoms and allow themselves to be propagandized by government-funded media, I can't dismiss your concerns. I would say, well, this is where we really have to hope that these rights and freedoms are sufficiently respected and understood and cherished by 90 or 99% of the population. That's the safeguard.
Okay, let's hope we don't have to get
well,
there.
We saw these terrifying arguments during the Public Order Emergencies Commission.
Right.
We saw these senior bureaucrats saying, well, we should broaden the basis for what could be a national emergency. Like if there's severe economic problems, we should be able to start issuing emergency decrees, and what you can freeze bank accounts because unemployment and inflation are running rampant. I mean, that's frightening. But they were actually suggesting that the Emergencies Act boundaries, which were violated by Trudeau, and one of the Justice Centre's court actions resulted in played a role in that ruling that was issued in January 2024, where the federal court said that there was no national emergency and the Prime Minister acted illegally when declaring there to be a national emergency. There you go.
Yeah, I was there when Freeland was testifying, and I paid very close attention to her. And she quite literally said the economic reputation of Canada on a global stage was enough to cause an emergency, because if we couldn't attract investment and battery factories and this kind of stuff, because it was Stellantis who called her and said, hey, look, we're concerned about this Windsor border thing. We need you to take action. And she said that was enough for her, in her mind, to say that we were on the verge of an economic collapse, which is more of a testament to her function as the finance minister at the time, because really we shouldn't be on the verge or on a cliff of any kind. But that's what she was testifying to, economic emergency, and that was enough in her mind. And if we have something like, I don't know, Trump with his tariff things, he's talking about using economic force against Canada to kind of force us into maybe joining them. Like, this is all rhetoric happening right now, and it may not materialize. But I can see how quickly, if we got into empty shelves and we couldn't get produce out of the U.S. or something, that Canadians could see it as an emergency. And as you saw, John, it just takes the media to say emergency. The government doesn't even have to use that word. But the media could, and boy, they can get a lot of people to fall in line pretty quick. Now, you did say trigger with like a non-confidence vote, but Carney met with Singh. The rumor out there is they struck a deal. So what deal could they have struck? Is he going to hold off until October? Is there some sort of spending that they're going to agree to? I think Canadians would put up with October, but not any further. Like if we don't get to the election that we had set October 20th, 2025, I think Canadians will lose their mind. But is it possible with consent from NDP that Carney could stay unelected because we're so close to an October election? Maybe the Governor General agrees, and we can actually see that all the way to then.
I don't have the answer to your question as to, what is the legally required time period, if any, when, again, let's say it's Carney, right? If Freeland wins the Liberal leadership race, it'd be a lot simpler insofar as she's already an MP. Freeland could make, if she wins, and if we're not successful in our court action, and if Parliament comes back only after the 11 weeks have elapsed, and they come back March the 24th, we could see Singh, keeping a Freeland minority government in power the same way that Singh kept Trudeau in power. So it is conceivable, yes. Now, but if Carney wins, I apologize. I don't know whether there's a constitutional convention or tradition or requirement as to whether he needs to run in a by-election immediately, within a month or 6 weeks, or whether he could govern for six, if he could govern for months on end. You probably see another court action filed to get a court ruling on what the status is, and can a prime minister who is not a member of Parliament rule the country for months on end. I could see a court application being brought to get clarity on that question.
Yeah, my research says the Governor General would approve or disapprove it. It would be on the request of the PM. And if Carney says we're prepared to do the election in October because of the Elections Act, it's a set date, it's the next set date, and we'll do it then. And if we're having this conversation late March, the Governor General might say, all right, like it may not be worthwhile having a by-election and then a couple months later have an election. So it might be conceivable that they even say for the price to Canadians, it's probably best to just wait till the election, and that's on consent because the NDP could actually agree with that. So it'd be a harder argument if Canadians had to go to court, I think, to force it. So let's talk a little bit more about yours. What's the remedy you're looking for? The Parliament to come back?
Yes, in the United Kingdom, the Supreme Court ruled that the advice given to the Queen, at that time was Her Majesty Queen Elizabeth, the court didn't fault her for taking the advice of the Prime Minister, because that's just a convention. And I would not want to, go after the Governor General of Canada for having, accepted the advice of the Prime Minister. That's how things work. But in the United Kingdom, the court got around this in a very clever way. They didn't criticize the Queen, and they didn't say that the Queen should have rejected the advice of the Prime Minister. What they said was the Prime Minister's advice to the Queen was unlawful. So they attacked. Well, the court didn't attack. They voided. They said the Prime Minister's advice to the Queen was unlawful, and then they said prorogation of the British Parliament was null and void. And so we're going to carry on as if Parliament had not been prorogued. And the very next day, all the MPs, I saw this on YouTube in the past week, all the MPs were back in the House of Commons, and the opposition MPs were basically reprimanding the government and holding the government to account for its saying, look, you prorogued Parliament illegally. This is a disgrace. And the government minister said, no, we did this in good faith, and it was the right thing to do, and we respect the court's decision, but we did act in good faith. And so you had this debate the very next day. So what we're hoping for as a remedy is that the court would say that the prorogation was null and void, and MPs are going back to work the next day, and that would open the door for a non-confidence vote. It would also provide another opportunity to the NDP leader to keep the government in power and say, well, we're going to allow the Liberal Party a whole bunch of time to have its leadership race.
Yeah, that would be interesting on how that works. Now, how quick can you get into court? Like, do you have a court date? It's not going to be April, I hope. So how quick can you get into court for this?
So we filed our papers on Tuesday, the day after the Prime Minister announced his forthcoming resignation.
You guys are quick.
We got some fantastic lawyers. We've got James Manson is one of our Toronto lawyers and doing a fantastic job on this file. And so we've asked for an expedited hearing, which every litigant is free to ask for. We don't want this to become some moot point. We don't want the government to be arguing in March or April that it's moot and we shouldn't get a ruling. And so the delay tactic started immediately, because the first thing that the Crown said was,
expedited.
They said, we're not prepared to provide you with our position as to whether or not this should be urgent. We need time for that. We want to come back next week just to tell you what our position is. Fortunately, the court did not take kindly to that and said, well, you're coming back very soon to tell us if it's urgent or not. So they came back a day or two later and said, our position is that this is not urgent. So now they're forcing us to make a formal application for a ruling that this is urgent. So that's been made. The government earlier today submitted apparently 200 pages of court rulings and documents and an affidavit, so on and so forth, to argue that this is not an urgent matter that should be moved forward quickly. We're expecting a ruling. We think we have a good shot at winning, but I'm not making predictions. But we're expecting a ruling between now and Monday morning that the court will say, no, this is going to be expedited. And on Monday afternoon, we hope to be back in court to nail down a timetable where we're going to have the court hear the application, hopefully before the end of January, and issue a ruling, hopefully in early February. And so, we're going to have this move as quickly as possible. And as well, if there's going to be an appeal, which there very well may be, if we lose, we'll appeal. If the Crown loses, they'll probably appeal. And Federal Court of Appeal can also hear this very quickly, I think.
Well, you guys moved pretty quick, but a 200-page response on why this isn't urgent. It sounds like maybe they were ready for some of these challenges, because that was pretty quick for even them to turn around, don't you think?
Well, I haven't read the 200 pages, but I'm told that they don't really have strong arguments as to why this should not be urgent.
Well, yeah, they set a time to come back. We got 11 weeks to hash this out, whether or not it was legal. And we know they like the moot argument, right? We've seen this a couple times already.
Sadly, yeah.
Yeah. So hopefully you're very successful and get that. I'm not going to make a prediction, but if this isn't urgent, then what is? So if this shouldn't be expedited, what should be? Like, what would be the threshold if it's not something like this? Our government is shut down. We have a complete stop to the process of Parliament. If this isn't urgent, I don't know what could be. Is that basically your argument? Like, what could be an urgent? Yeah.
Yep.
Yeah. Well, I'm sure they're going to have a good response. Is this public? Are you guys sharing all of this? Are you publishing it like on your website or anything?
James Manson has done, I believe, 2 separate videos. One of them got 360,000 views. I'm jealous. But
we'll see what we can do tonight for you.
But James Manson, I anticipate, will be releasing another video soon, as soon as there's something to report. And that'll be coming out, if not on Friday, then on Monday. And if it's not a video by James Manson, it'll be a news release from the Justice Center to provide an update. And so we're going to keep our supporters and all Canadians informed.
Is this going to be streamed in any way? Are there going to be any open court? Are we going to have a Zoom link? Do you know if we can get any of that?
I believe not, but I'd have to get back to you by email and check with James. But I don't believe this is going to be live streamed from the courtroom. It'd be great if it was, though. I think we'd get a lot of people watching.
Well, actually, on that topic, why isn't everything available to the public, like live streams and transcripts? And why is it really kind of in publication bans? Like I was about to say to you earlier, it's not your fault that you don't know much about Coutts and what happened in Lethbridge, because there's publication bans in place and it's hard to even get information out. So how can you deal with some of those?
Well, the courts move at a slow pace and they are in charge of their own procedures. I don't see a reason why courts, would not or could not, for example, post the factums and the briefs. And I believe that's not the case. They definitely post their rulings, and that's fine. Yeah. But with the internet, there's no reason why they couldn't put on the plaintiff's factum and the defendant's factum. Certainly in important constitutional cases, you could see all of that. The Justice Center, we're doing our part, for example, on the court cases that are referenced in my book, we are posting the government's evidence on our website so people can see with their own eyes, can read through it and see how pathetic it is and how the governments are not placing compelling evidence to justify lockdowns before the courts. They're making a lot of assertions. They're claiming lockdown saved lives. They're making false claims like, COVID is the worst global pandemic in a century. It's unprecedented. The government makes all those claims in its evidence, but the evidence to back up those claims is not there. People will be able to see that when they go to our website and see the government's documents that we're posting in respect to these constitutional challenges.
Yeah, I'd be curious what kind of system we would have if things were streamed real time. You could get transcripts, you can get copies of exhibits and stuff as they're entered, because we may end up having a society that's really connected and interested in what's going on and contributing. So they'll watch and maybe they'll catch something or go look something up. Like I remember Johnny Depp and Amber Heard, their trial. There was this opening statement by Amber's team where she said, yeah, and she would carry around this makeup with her because she would be beat all the time. And then the internet actually zoomed in on that, and it turned out that particular one that she claimed was in her purse at the time wasn't manufactured at that point. It was 2 years later. So it was physically impossible for that particular item and that particular opening statement to be factually correct. And that's because of the real-time viewing. People were watching this, and they can kind of assist the process along. I wonder if that could be why we don't have that in Canada. Like, I wouldn't call that interference. I would call that assistance. But maybe they don't want to have it exposed. Maybe sunlight is the best disinfectant, and they don't want that. Because I've heard in the court many times, justice is meant to be seen. But yet, I'm a journalist, and I can't even get the Zoom links or the transcripts without paying for it. So justice is very difficult to see.
Well, to my mind, it's a logical extension. There's a basic principle of transparency, and that is the rule. Now, there are exceptions. Okay, so if let's say there's a civil claim or a criminal claim, and it involves a child who was sexually abused, that sort of thing. You can always, and we see this all the time when they you have court cases that are initials, OMS versus JVT. And so it protects the anonymity of the child. So you can make exceptions, that's fine. But the starting point is that you can walk into any courtroom in Canada, whether it's criminal case or family law or civil or constitutional, you can walk in and watch. Now, if there's a huge interest in a particular case, there's practical reality that they can only allow, 100 people in the courtroom. But with the technology that we have now, it seems to me that extending that same principle of transparency, it's a longstanding principle that's been there for centuries. You can expand that and say that, it's not that hard to hook up a camera and live stream. Need not be exceedingly expensive either.
Well, I think COVID almost created that condition. Basically, every lawyer and judge and court clerk, they're all familiar with Zoom and other technology now. We kind of did that as part of the lockdown to keep justice moving. Why don't we just continue that? Like, why don't we just go ahead and do that? And then also public record is another one that I really touch on, because I'm still waiting for a copy of the record for the Coots trial. We're now months later. Why isn't it available? As soon as it's produced, I can just go get it. It is expensive too. Like, to actually get a copy of that is very.
I don't really see what the point is, because the transcript is created. There could be some costs involved in audio recording,
certifying it maybe, or certifying it. Yeah, but they just have like a raw copy right away.
I mean, certainly the audio recordings, which exist anyway, I don't know why they could not be posted online. I don't get it. There is an expense. My understanding is that the audio recording takes place automatically, but then it's not always typed up by a court reporter. So, if I'm in a court case, if I'm a lawyer acting in a court case and I want to appeal it, I have to pay extra money for the transcript. But once the transcript has been created and produced, I don't know why it couldn't be. If the court reporter has been paid, I don't think it should be like a book where there's copyright. I don't see any rationale for that.
Yeah, I would agree with you. If it's been ordered and produced, make it available to anybody. The next person, it's free, and you can download it as well. And I have a reporter friend, And she's telling me how AI and technology is slowly replacing them too. So there is going to be more AI-based transcripts, and having them certified to make sure all the names are right and all the numbers are right and is accurate. I can see why that might take a little bit of an effort. But for the public, at least a public record, we should be able to get our access to it. And that includes exhibits, anything that's entered into the public record, especially if they're digital or they've been digitized, like scanned in. Absolutely. I would love to see Canadians get far more interested in the judicial system because they have access to it.
Well, right now,
Alberta is bad too.
The Justice Centre's, trying to fill the gap to a small extent for our court cases. For example, the Hillier case in Ontario, where the judge completely ignored lockdown harms and devoted not a single sentence to the very damning report of lockdown harms that was submitted by an expert witness. So we've posted that on our website. The expert is Kevin Bardosh, and there's a lengthy report that outlines all of the lockdown harms that was totally ignored by the judge. You can read the report, then you can read the court ruling, and the judge just says, he's not a public health expert, and just doesn't even say why he's dismissing Kevin Bardosh, who is very much a public health expert, doesn't even say why he's dismissing it. And then that becomes this excuse for disregarding lockdown harms, which is a gross violation of the Charter, which requires that courts take into account if there's a health order that violates a charter freedom, then it's incumbent on the government to show with convincing evidence before the court that the lockdowns are actually producing more good than harm. And it's incumbent on judges, if they're going to rule in favor of the government, they need to explain why and how lockdowns are beneficial. Good luck with that. And they have to show that the lockdowns produce more good than harm. And this gets into what I get into in the book, and I go through specific examples where judges just completely ignore the massive harm that lockdowns inflicted on many Canadians.
What process would you have preferred or like to see take place? Because it would be difficult, I think, for both sides to try and for example, science. So whether or not this was safe and effective, the government might bring their own people that say, yeah, it is based on Pfizer or based on our research, and because national security or other reasons, we can't share it all with you, but trust us, it's good. And then you bring in your own counter science or counter doctors. How would you want the court to handle that? Because they're not experts yet. So how would they handle it?
Well, courts deal with conflicting expert reports all the time. There's one judge in Ontario, Renee Pomerance, and in a decision of Ontario versus Trinity Bible Chapel, she actually said, I am neither equipped nor inclined to resolve scientific controversies regarding COVID. And it's just jaw-dropping because this very same judge, she's been on the bench for a long time, and in criminal cases, actually there was a Justice Centre networking event in Toronto. I bumped into a forensic expert who says, I've appeared before Justice Pomerance as an expert witness in criminal law cases, because not every criminal law case has expert evidence, but some of them do. You have forensic evidence, and the defense and the Crown, they each have their expert. And Renee Pomerance, and other judges, they have to listen. And even though they might not be formally qualified, they're the judge, and they have to listen to the expert testimony, and they have to make a ruling. And they don't run away from that in criminal cases, family law cases, contracts, torts, whatever. And here we have violations of charter rights and freedoms. The government's admitted in court quite readily that, yes, our lockdowns and our vaccine passports do violate charter rights and freedoms. They admitted that, but they're justified. And then you've got a judge saying, I'm neither equipped nor inclined to resolve scientific controversies regarding COVID-19. It's obscene. And then another judge, Barbara Romaine in Alberta, adopted that and said, like Renee Pomerance, I am not an armchair epidemiologist, and I'm neither equipped nor inclined to resolve scientific controversies. And then she goes ahead and rules in favor of the government on the charter issues and says that lockdowns were justified. It's like, well, if you can't resolve the scientific controversies, how could you possibly issue a ruling in favor of
Right.
either side? But they go on to rule in favor of the government after having said they're neither equipped nor inclined to resolve scientific controversies regarding COVID-19. It's
Not
a sad state of affairs.
Completely true. Not equipped, I get it. You may have to learn the subject, but not inclined, that's your function.
That's your
Should be
function.
inclined. Yeah, you should be inclined to try and learn it. And if it takes extra time and we have to bring in more experts, or even the court can bring in their own expert as well, maybe that's part of the solution. If it's a really difficult subject, the court could also bring in a third expert to help them get through it or help educate them, kind of like a legal advisor, but a medical advisor to the court. Maybe this is a way to go, because not equipped, kudos for saying that. Good on her for that, but not inclined. That's your function. So you should be recused at that point. If you don't think you can handle this, maybe that's a reason for a recusal.
Well, and then this gets back to the cultural problem, right? Which I keep on harping on, because we've had a cultural decline in Canada from, say, 50, 60 years ago. We actually believed that our free and democratic society, our parliamentary democracy, our freedom of speech, the rights of the accused person to be presumed innocent until proven guilty beyond a reasonable doubt before an independent and impartial judge. We believed firmly that our democracy and our rights and freedoms were superior to Nazi Germany, fascist Italy, Imperial Japan, the communist Soviet Union, communist China, theocratic Saudi Arabia. Again, the external justification for repression doesn't really matter. We believed wholeheartedly that our free society was superior. And we've regressed away from that in the last 50 or 60 years to a point where a lot of Canadians, as we saw under lockdowns, a lot of Canadians don't really cherish these rights and freedoms, and they want to be led and guided and managed and controlled by an authoritarian leader. And so we need that cultural renewal where we move forward to a place where there's way more respect for charter rights and freedoms. When we get there, that will trickle up to the lawyers and the judges as well. Because what I've seen in the court rulings is that a lot of judges, they kind of pay lip service. Oh yeah, we've got the charter rights and freedoms, and that's important. Yeah, we recognize that. Yeah, the government did violate the rights and freedoms, but it's okay because it was a really bad crisis. Because the media told us so, and so we're just going to defer to government. You're seeing this excessive deference to government, as in that Michael McGaugh case in Saskatchewan, where he orders a girl to be injected and takes judicial notice of the fact that the vaccine is safe and effective for adults and children. It's just this extreme deference to government that has trickled its way into the legal profession, and it's from lawyers that it's from the body of lawyers that judges are appointed.
Now, government, in my mind, is really meant to be there to kind of protect us or ensure that we don't go around killing each other. But they're not meant to be our minds, our think tanks. That's not normally traditionally where we go for answers when it comes to knowledge and intelligence. But it seems to be the place now. It seems to be where people are getting their answers from. How did that happen? And when did that happen?
I don't know about how and when, but that's another case that I reference in the book. It's Justice Adam Germain from the Alberta Court of King's Bench. He ordered, I'm sure you remember this case. He ordered Pastor Artur Pawlowski. I'm sorry if I'm mispronouncing his name.
It's close enough.
He ordered Pastor Art that whenever the pastor speaks in public, the judge said, you must say that the majority of medical experts think that lockdowns are terrific and the vaccine is safe and effective. I'm paraphrasing. And this judge, there wasn't even any evidence before the judge about whether vaccines were safe or unsafe, effective or ineffective. There's no evidence. But based on what he's heard 100 times on the 6 o'clock news, he believes that this is true to a point where he's willing to order a citizen has to proclaim the government's narrative whenever he's speaking in public. Before he says anything against vaccine mandates, he first, by court order, must say that the vaccine is safe and effective. That's creepy. That is a totalitarian mindset where the court, which is an arm of government, thinks that it's entitled to order a citizen to proclaim something. And it would be wrong, even if it was a true statement that we could all agree on, that, gravity is real. A court should not order a citizen to proclaim that gravity is real, or, that we should be nice to Girl Guides who are selling cookies, or whatever. Even if it's something that we all agree on, it's just very totalitarian when a court orders a citizen to proclaim a message.
Yeah, when the government tells you what you can say or what you should say, and I think Jordan Peterson warned us about this, when you actually have compelled speech, like pronouns, I think he was highlighting this a long time ago, this is a slippery slope. And it won't be long before they're doing exactly what you just said there. Pastor Art has to put a disclaimer out in public that a majority. And by the way, when did science become democratic? Like, when did it become a voting thing? Like, I remember Einstein, there was this one time where they were trying to discredit him on a particular item. Can't remember what it was. And 100 scientists wrote a letter and signed it. And they brought this forward to the journals and the public, like that should dispel the myth. They called it a myth of Einstein. And his response was, but you only need one to prove me wrong. Okay. So
why do you need 100?
When does science become democratic and the majority rules in science? Like that statement that a majority of doctors agree, that makes no sense to me.
Well, and I addressed that in the book as well. In this Gateway versus Manitoba decision, the judge rules in favor of Manitoba. He says, these lockdowns did violate the freedoms of conscience and religion and association and assembly, so on and so forth. He doesn't explain why he prefers the government's evidence to the evidence of the citizens who are in court to fight for their charter rights and freedoms. But he uses this majoritarian. We had, as experts, we had Dr. Jay Bhattacharya, world-renowned. He was universally respected prior to 2020, but then suddenly he becomes, this anti-science Neanderthal kook because he's minority position amongst the doctors when it comes to lockdowns. But the judge says that Dr. Jay Bhattacharya, even with his 50,000 or 100,000 signatures, whatever it was, there's 50 or 100,000 medical doctors and other scientists who signed the Great Barrington Declaration saying that lockdowns were not the way to go. But they were still a minority. I don't doubt that they were a minority, but the judge doesn't explain in his ruling why he's rejecting the position of Dr. Jay Bhattacharya. What he says is, in not so many words, he says, well, Dr. Bhattacharya is part of a minority opinion. And, I'm thankful that he's, raising some issues, and I'm glad that the debate is continuing. But as of right now, it's the majority, I'm paraphrasing, it's not a direct quote, but the majority of doctors and other scientists are saying that lockdowns are terrific. So I'm going to run with that. He never explains why he rejects the evidence of Dr. Jay Bhattacharya. And worse yet, there's a second expert witness in that case, Dr. Joel Kettner, who was the former chief medical officer of the province of Manitoba. And he wrote a scathing report that basically destroyed the government's case for lockdowns. Now, would have been open to the judge to explain why he's rejecting Dr. Kettner's report. But what he does is he ignores it entirely. I think there's one brief reference. Oh yeah, we also had, Dr. Joel Kettner. That's it. He doesn't explain why Dr. Kettner's devastating takedown of lockdowns should not be followed.
Now, what if we actually took a step further and we did it by poll? So the court polled the community or polled citizens, and we have to rely upon the people who make the polls and collect information to provide it. Would you feel more comfortable or less comfortable with that kind of setup?
Well, very uncomfortable. The reason why we have charter rights and freedoms in the first place is to protect minority rights, and that would be minority religion. If you took a vote, should Jehovah's Witnesses be barred from going door to door with their literature? Should Jehovah's Witnesses be prevented from standing on a street corner or handing out literature? You might. I would hope that the vast majority of people would say no. They have a right to disseminate, to promote their religion. But what if we had, 55% or 75% of Canadians saying, well, Jehovah's Witnesses are really annoying. They get on my nerves and I don't like their religion. So let's say, we'll allow them to practice their religion in their house of worship, we'll let them do that because we're very magnanimous, but they shouldn't be out there spreading their stupid religion on street corners. It's the same thing with speech. The reason why we have protection for freedom of speech in the charter, or if we had no charter, it would hopefully just be part of our understood constitution. The reason we have that is to protect minority expression that 99% of the people believe is wrong or false, that you can still go out there, and even if you're part of a 1% fringe, you can go out there and explain your opinions on philosophy, religion, science, what have you. That's why it's there. So these things should never be taken to a vote. That's why we have the charter and the constitution, is that we can't just vote unpopular opinions and unpopular religions out of existence.
Well, let's take it a step further. We have some protection around political speech and the ability to run for office and for politicians to come forward and represent. We've got a lot of protection around that, don't we?
Well, that's being dismantled. In one of the Justice Centre's court cases, there's a councillor in Ontario. His name escapes me and the city escapes me. Sorry. Anyway,
No
he was a elected city councillor in a town not that far away from Ottawa, maybe within an hour or two driving's distance, and he participated in the Freedom Convoy. He was chastised and reprimanded and censured by his own city council. They docked him pay. This is just a brutal attack on free expression. And if we don't change our culture, we're going to see more of this coming. I mean, the Justice Center is going to keep on fighting at the front lines, but that's a Band-Aid solution. It's necessary. We need the Band-Aid, but really we've got to transform our culture. When you've got, a grandmother being shut down, that's another court case in BC. Grandmother tries to speak at a public meeting of the school board and gets her microphone turned off because she's disagreeing with the woke progressive narrative. It's really scary when there's such a disrespect for free expression. We saw it again federally with the Bill C-63, the Online Harms Act. Mm-hmm. Very wickedly authoritarian legislation to silence people that disagree with the powers that be.
Well, let me give you two more examples. Councillor Lisa Robinson in Pickering. So same thing. She's been first to start off with being told to shut up. Then it was muted. And then they started to take away her pay. So they've done that, I think, 3 times now. So it's a total of 9 months of her pay. So 3 segments, I think, of 3 months at a time for 90 days. And now the most recent one is the councillors and the mayor have teamed up to file a criminal complaint against her for the actions of what they say are her supporters against them are causing fear. So they've really escalated this particular fight against Councillor Lisa Robinson. You may want to take a look at that one because she's a single mother, she's a paralegal, hasn't had pay for 9 months, and she's trying to still do her job. But now they've actually initiated with the Ontario Provincial Police a criminal complaint against her. I think that is abuse of the highest kind.
Oh, absolutely. Now, there are criminal law prohibitions against hate speech. It's pretty, there again, we depend on a good culture to make sure that those laws are not abused. If you publicly state, if you call for death of, a group based on their skin color, ethnicity, their gender, their sexual orientation, I'm not even going to utter examples, but if you say, death to the such and such group, okay, that's advocating for genocide and willfully promoting hatred. Those laws are on the books. So if anybody, if these mayor and councillors are getting and any kind of a death threat, you turn that over to the police, and the police can look after it. But if it's political speech and you're getting some citizens riled up, and they're sending angry emails to, the Justice Center got a fair amount of hate mail in 2020 and 21, 22. We were the only civil liberties group in Canada that was calling for an end to lockdowns. We got hate mail. Well, we sucked it up. Now, if that crossed the line and said, John Carpay, I know where you live and I know where your children go to school, that I would take over to the police. And that's probably criminal. Right. But we gotta grow a thicker skin. And I'd be I don't know what was said to the Pickering mayor and councillors, but I would say, unless it's a death threat, it's just political speech.
Yeah, and even if it was a death threat, it's not Councillor Lisa Robinson's responsibility on a criminal level either.
No, absolutely not. Because if we adopt that logic, then, good
We're all
grief.
screwed.
If somebody, if somebody burns down the Justice Center's office, then what, criminal charges to people who said bad things about the Justice Center on the internet? I mean, it's a terrible example to use, but I mean, we can't go for that kind of logic where you run a risk of criminal charges because you've supposedly incited somebody else to do something. Like, no.
Well, even if the person was standing there with a gas can saying "Viva le Trudeau," and he was very clear that he wanted to support Trudeau and said, "I love Trudeau and I'm doing this for him," and he's burning down your building, I still don't think Trudeau's responsible.
No, that's correct.
Even if, that's a very dangerous slope, and they're trying to do that. I really hope that the OPP do the right thing and they go ahead and figure out who the real harassment is coming from, because filing a false claim of harassment against a counselor itself should be something that can be dealt with by the police. One more, and then we're going to jump over to the other side. A couple days ago, I'm not sure if you're aware of this, but the Leaders Debate Committee had provided a rule change on the Leaders Debate. So previously, you had to qualify for 2 out of 3 of the qualifiers. The first one was you have a seat in the House. So if your party has a seat in the House, that's one of the qualifiers. The second one was 4% of the popular vote in the previous election. And the third one was 90% of your candidates running in ridings. So 90% of the ridings have to have a candidate. And if you can get 2 of those, you are invited to the Leaders Debate. So we were very pleased with the PPC because Maxime, we got 840,000 votes, and that took us over the 4% threshold. And we are planning to run again, because we did qualify last time, more than 90% of the candidates. 2 days ago on Twitter or X, and there was an announcement from the Leaders Debate Committee. They've changed the rule. The second one, so they now, instead of 4% on the previous popular vote of the election, it's 4% of the polls national average 28 days before the election. So now, based on Angus Reid or whoever else is providing the polls, we have to score higher than 4% of support there. We went from having an elected number, so the actual tangible votes that are associated with Canadians who made that choice, to put it into the system of pundits and pollsters. And we've just seen Angus Reid release a poll for the PPC support. Well, actually, it was for federal support, so they were all on there. But they only had 1,975 respondents online. That equates to about 5.76 people per riding. So about 6 people per riding is what's responding to this to reflect. We're very concerned because that doesn't sound fair. And we're also getting reports and screenshots of polls coming to people that doesn't have the PPC listed. So it says Liberal, Conservative, Green, NDP, and other. So PPC is not even listed. So how are we going to have a fair leadership debate? How is this not against the Constitution? Because you're definitely shutting down the speech of one person, because this particular rule change only impacts Maxime Bernier. The 41 million Canadians, only he is impacted by this. So what can we do about that?
Well, you're certainly, this change to the rule certainly diminishes the ability of Maxime Bernier to be heard. There's no doubt about that. From a constitutional angle, if this was taken to court and if the Leaders Debate Committee or whatever the body is, they would say, look, we're not impeding the freedom of expression of Maxime Bernier. He can speak live and in person, he can travel, he can be on the internet, et cetera, et cetera. I think it's kind of a complex and difficult issue in one way, insofar as you always have a dozen parties. Some political parties have, maybe they ran 2 candidates, but they still exist, they're still real. How far, the practical question, and I don't know what the answer is to the question, but how far do you extend the net? How wide do you extend the net? Mm-hmm. There have been times in the past where we've seen leaders' debates where it's only the leader of a party that has at least one MP elected in the House of Commons. Now that would discriminate. It would have discriminated against the Reform Party in the 1988 federal election. They had no MP. In 1989, Deborah Gray became an elected Reform MP in 1989. So the 1993 election, you would have had the Reform Party there. But I think it's a difficult one to grasp, to deal with, because it's going to be unfair in some way to somebody, no matter how tight or how broad you cast the net. And I'm not sure if I don't think there's a constitutional answer. There is an answer in terms of fairness. What is a fair policy? That's open for debate. I don't really see, off the top of my head, I don't see a constitutional angle to it that, Maxime Bernier or anybody else has some sort of a constitutional right to participate in a leaders' debate.
Fair enough. Okay, so it's not written in stone that you have the right to debate, and I get that. And if the argument is made, well, this is so that a new party can go ahead and become a leader debate if they get support quickly before an election because they don't have previous election results, I get it. Then that's what that magic word of "or" is helpful. So 4% of the popular vote in a previous election, or 4% of the poll for the next election. If you qualify for either one of them, then sure, it makes sense. Because I do agree with a bar being there, so we don't have 30 people on there. But 4% of the previous election popular vote, that was a bar. And then
that's a pretty high bar too. I think if you've got 4%, considering our electoral system, right? I mean, if this was Italy or Israel or the Netherlands or some country with proportional representation, it's a whole different ballgame, because you can get, one or two MPs into Parliament with only 1% of the vote.
Green.
But here it's a very different. Our electoral system discriminates against smaller parties, and then to what extent do you remedy that discrimination when it comes time for there to be a leaders' debate? It's
completely true. And independents too. There's no path for an independent to get into the leaders' debate.
That's true as well. I do think. I mean, for what it's worth, it seemed like it was fair that, you need 1 out of 3 or 2 out of 3. You need a seat, 4% of the vote, and candidates running all over Canada. It seemed to be fair. But I think if I were Maxime Bernier, I would try to, it's going to be an uphill fight for him.
It's tough. And with resources and an election, like, we're going to have to make decisions and tough decisions. I think the solution to this one is to just come back with 10% support. Let's go double and triple the party. But I still think it was incredibly unfair. I think the people are watching now, and it's just really kind of reinforcing that there is a uniparty, because they're really just pulling out all stops to stop them from talking. And I think it's unfair. And especially when you look at the Angus Reid one, like in a month, it goes from 5% to 3 to 4 to 1% for the PPC, like a dramatic decline. But in the party, 4 out of 5 people aren't missing. Okay, like everybody's still here. So I'm not sure where they're getting those numbers from. And when you're seeing less than 2,000 as the sample,
I also think it's rather unscientific to rely on polls. You probably remember the 2016 election, the U.S. presidential election in
Hillary was
2016.
supposed to win, right?
Everybody, I thought Hillary was going to win. I couldn't believe. I was really surprised that Trump won, and everybody. It was a foregone conclusion. It was a done deal. Hillary was going to win, and all the polls said Hillary was going to win by a landslide, and then Hillary lost. And to start relying on polling companies, I think is at least if you have 4% of the popular vote, you could still argue that was unfair. In either direction, you could argue it should be higher or it should be lower, but at least you've got some hard data, which you don't have with the polling.
Well, if we had 4% in the last election, at least put us as an option in the poll. Don't stick us under other.
Yeah, no, that's definitely unfair.
No worries. But thank you very much for bouncing that around, because Lisa Robertson, that's a really big one. They went to the OPP on her. She's stressing. She hasn't had pay in 9 months. And it's all because she is actually fighting for everything you and I would agree with. It's just the narrative doesn't. And then certain communities with a couple initials in them definitely don't agree with her. And because of that kind of pressure and that kind of cancel culture that we have, the mayor and the people around him are scared of that group, but not scared of the police enough to file a complaint against a sitting councillor. So hopefully you pay attention to that one, but you're a really busy man. So thank you very much for all the work you're doing. Please hang on. We're going to jump over to our supporters. We have a few questions for you. But if there's something else you'd like to leave with the public, so we have a great audience here right now.
Well, in terms of Lisa and Pickering, I don't know the facts and details. I had heard a little bit about her case yesterday or earlier today. I can't remember. I've asked our legal team to reach out to her. I don't know if she has a lawyer or not, and it's always dicey. You're not supposed to, if somebody has a lawyer already, you're not supposed to be seen to be trying to get the person to dump their lawyer, and so we have to kind of tread carefully. But I definitely, we're in the process of reaching out to her, getting more facts and finding out if she has a lawyer or not. And, we'll kind of take it from there and see what happens.
I can tell you, before the criminal investigation started, she did not have a lawyer at that time, because I recommended she reach out to you. So hopefully maybe that's happening, and there will be a connection there, because she certainly needs the help. But thank you very much, John. So hang out, and we're going to have a couple questions for you, but we'll say goodbye to the public now. So public, there you go. Please get this out. Proroguing the Parliament. We talked about it. Go check out John's book. It's very important to stay on top of this. And I love how you were breaking it down case by case and providing examples. And absolutely, I think it's corruption by fear. I've seen this in the bail hearings. I've seen this in the trials. I've seen it with Pat King. Remember, they threw him back in because of a bail breach that really didn't happen. And he had to go back in for another week before his sentencing. It's all crazy. And I do think corruption by fear is a really hot topic. So please check out that book and make sure that you wait for John to be around. It sounds like there's going to be a tour. March, I think you said, March 6th in Edmonton. And there'll be other locations. Where can people find those details?
So the book goes on sale on Tuesday, January 21st. It's on Amazon.ca, and it's $24.95. Audiobook is already available today. If people prefer the audiobook, I think it's $8.95, $9.95. I'm sorry, not the electronic book, not the audiobook. The ebook is already available. Amazon.ca, Corrupted by Fear. The hard copy. It's a soft cover, but the physical book is going to be available Tuesday, January 21st. And if you're able to, buy it on that day, because if Amazon gets a lot of first day sales, Amazon starts to help promote the book on the internet. So hoping for lots of sales on Tuesday, January 21st.
Absolutely. And we'll make sure we get in line for that. So the 21st, we'll make sure. We'll also have that link. We're providing a link for your ebook, and we'll get the link for the hard copy book as well.
Awesome.
So thank you very much, John. So hang on. Well, public, there you go. Share this out. It's really important information. And thank you very much to the Fresh Grill Kitchen here in Stony Plains. We've set up again. We've got a small audience, and it's growing. So we'll try and be back every Thursday. So if you're in the Stony Plain area, keep an eye out for us. And Tuesdays for Drayton Valley, and Wednesday for Breton. All right, public, have yourself a great day. You make sure you take care of yourself and your family. You shake the hand of a neighbor or a stranger. And why do I keep reminding you about this? Is because I love you all very much, and God bless.
All right, folks, that's a wrap on the public portion of today's show. Thank you for watching. If you found this valuable, please share it with friends and family. Want to connect with the Lavigne Show community? Become a free member today and join the vibrant space dedicated to champion justice, accountability, and open dialogue. Engage with myself and fellow advocates, and stay in the loop on our latest broadcasts. Want to do even more? Become a supporter for just $7 USD, $10 Canadian monthly. If you can afford more, you're welcome to increase your support, helping us stay truly independent. Supporters unlock full, uncensored live streams, interactive Q&As, behind-the-scene content, and so much more. Ready to join? Head over to thelavineshow.com to become a member or supporter. If you have any questions or need help, email members@thelavineshow.com or call or text 587-673-9955. Supporters, we'll see you shortly. Thank you, and God bless.